Start. It was only when the second appeal was taken up for hearing by a learned single judge of this court by a letter dated March 22, 2013, the learned advocate of the respondent number 1 informed the advocate of the appellant that during the pendency of the appeal, the respondent numbers 2, 3, 4 and 5 died on March 5, 2012, April 18, 2012, in December 1989 and May 4, 2008, full stop. He further submitted that it was only after an order being passed in the appeal by a learned single judge, by a letter dated May 3, 2013, the advocate of the respondent number 1 informed the advocate of the appellant or the particulars legal representatives of the deceased respondents, but did not furnish their respective relationship with the respective deceased respondent, full stop. According to him, instead of informing the appellant of relationship of the legal representatives with the respective deceased respondents, on February 10, 2014, the respondent number 1 filed the application for recording abatement of the appeal and the appellant filed his affidavit in opposition in the said application on April 16, 2014, full stop. The appellant filed the application praying for condonation of delay and setting of the abatement on April 23, 2014, full stop para. Mr. Raichaudhuri strenuously urged that the respondent number 1 has failed to comply with the mandatory provision of Rule 10A of Order XXII of the Code of Civil Procedure, hereinafter called the Code, to inform the appellant of the dates of death, the respective respondents and the particulars of the respective legal representatives of the deceased respondents, full stop. Thus, according to him, there was no scope for the appellant to file any application for substitution of the legal representatives of the respective deceased respondents within the stipulated period prescribed for 90 days from the respective dates of the deceased respondents, or to file the application for setting of the abatement of the appeal against the deceased respondents within the stipulated period of limitation, full stop. He admitted that since the second appeal arises out a partition suit and the right of the appellant to proceed with the appeal does not survive against the surviving respondent number 1 alone, the legal representatives of the 4 deceased respondents were required be substituted as respondents in the appeal, full stop. He did not dispute since the legal representatives of the respective deceased respondents were not substituted in the appeal, the appeal against the deceased respondent numbers 2, 3, 4 and 5 has abated by operation of law after 90 days from their respective dates of death, full stop. However, he contended that since the appellant was not informed of the death of the deceased respondent numbers 2 to 5 and the particulars of the legal representatives of the respective deceased respondent, the appellant could not file the applications for substitution of the legal representatives of deceased respondent, within the statutory period of limitation, and this court would liberally exercise its discretion under sub-rule (5) of Rule (4) of Order XXII of the court and condone the delay in filing the application and set aside the abatement of the appeal, para. Mr. Raichaudhuri strenuously urged that while dealing with an application for condonation of delay in filing the application for setting aside of abatement of a suit or appeal, the court is to do substantial justice to the parties by disposing of the matter on merits and the expression sufficient cause employed by the legislature in sub-rule within bracket 5 of rule within bracket 4 of order XXII is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the ends of justice, that being the life and stop.